Hello and welcome to CommonSense Lawyer Frequently Asked Questions. A reminder that we are located in Saskatchewan, so if you are from somewhere else in the world, this information may not be applicable to you. In addition, we always like to remind our audience that these videos are for informational purposes only and should not be used as legal advice. If you require legal advice, please consult with a lawyer. Today's question is, how do I pick a process to use? It is often helpful to start with the least formal process option and then move through the formality as needed. For example, discuss with the other party involved if you can reach a solution together without the assistance of a professional. If that will not work, then the next level of formality that might be suitable is mediation. And maybe if that doesn't work, arbitration, and so forth and so on. And I'm going to share with you a diagram that you might find helpful here. I'm just going to show you what this looks like here. And here we go. Okay, so down here, we've got amicable. So this is when you can be really friendly with each other. It keeps the hostility really low. You're just having a conversation to figure out if you can come to a solution. And also you can see on this graph that it is the least formal and the least expensive. And then the next step up here is mediation. And this is kind of a neutral process. So it might not be totally friendly, but it's definitely not totally hostile. And it's in that mid range of how expensive it is and how formal it is. And even within mediation, it can be more expensive or less expensive, more formal or less formal, depending on what the parties involved are needing. So if my neighbor and I are having maybe a little bit of a dispute, there was like a tree overhanging our property and I trimmed it and he didn't want it trimmed. I might want mediation and it might be really inexpensive because maybe I only need one meeting and maybe the formality that I need is very low too. Like we don't need a written agreement or anything like that. We just need to, sit and have a chat about what's going on between us. On the other end of things, maybe I want to negotiate my separation agreement. Maybe we have lots of property, we have lots of kids, we have lots of assets to divide. So I'm going to need a lot of mediation meetings to figure all those things out. So that expense is going to be a little bit more. And that formality that I'm needing out of the process might be a little bit more too. I might need an agreement at the end of it. So that I can take that to my lawyer to get independent legal advice on it. Again, that's increasing the formality, increasing the expense, and then maybe that's because I'm using it to refinance my property. So, and again, if mediation isn't going to be suitable for you, or if mediation doesn't work and you're going to go to the next step, that's arbitration. So it's usually a little bit more expensive than mediation, and it does have added formality because at the end, the arbitrator is going to write you what's called a decision. And you can choose for that decision to be binding or non-binding. Maybe you want the arbitrator to just give you an opinion. So that might be a non-binding arbitration. Or you might want the arbitrator to give you a binding decision. So a binding decision is, this is what we're going to go with. It's not an opinion. It is, hey, this is what these two people are going to go with. So you get that decision at the end, and you're held to it. So that formality is going up, that expense is going up. And arbitration is still in that neutral zone, though it is creeping up to that more hostile zone. Then we get to litigation, which is the most hostile, the most formal, and the most expensive. So in this situation, you're both going to be paying for lawyers, or multiple people will be paying for lawyers. It's very formal because you're asking a judge to make a ruling for you. You might have to attend at court, which is a very formal place. You're not allowed to have your cell phone out. You have to be dressed a certain way. You have to be quiet. You might have to be called to share some kind of testimony. And I also put this at the most hostile because you are arguing positions, and sometimes there gets to be a little bit of mudslinging, and also there's what's called affidavit evidence, and in those affidavits people can say some really damaging things to each other and you can't take those back. So if you start here at the tippity top and try and work your way back down to a conversation, you're probably not going to have any luck there because that relationship is so damaged. You are so depleted financially, you're exhausted. Whereas if you start at that low level, if you start at that amicable, not a lot of expense, not a lot of formality, and then creep up the stairs as things aren't working and as things aren't unraveling, um, that is usually the best choice scenario. Now, in your particular situation, there might be specific reasons why you can't use a conversation. Maybe you have a court order which bars you from talking to each other. There could be various reasons. So if you want to discuss your situation further with us and we can help you pick the best process for you, please call us to book a consultation. Thank you so much for watching our video and have a great day.